There clearly long ago should have been some sort of distinction between a non-violent felon and a very violent felon.
We are the Armed Attorneys. We're here with an exciting update. Another gun law found unconstitutional under the New York State Rifle and Pistol Association v. Bruin standard. Now, this is one that we've been waiting on for quite a while with regard to felons and their firearms rights. But before we begin, show your support for the Second Amendment by hitting that like button. And today's video is brought to you first by our friends over at Sonoran Desert Institute. Take your hobby to the next level. Check them out at sdi.edu/armed-attorneys. And our friends at Acre Gold. Here's something new. You know how the price of gold has been all over the place lately? Now there's a new way to buy gold through a company called Acre. You pay each month, and once your gold stash reaches a price of their gold bars, they discreetly ship Acre Gold to your house. And just recently, they introduced a new $100 a month subscription for a 5-gram gold bar. Acre lets you invest in physical gold without coming out of pocket all at once. They're also a fantastic hedge against inflation, which we've seen all over the place with gas, lumber, and food prices. So check them out at getacregold.com. All right, so today we're talking about cases styled Range versus the Attorney General of the United States, 21-2835. This is out of the Third Circuit Court of Appeals. That's Pennsylvania, Delaware, New Jersey, and the Virgin Islands, if anybody's keeping track of that stuff. And this is a fascinating case. Tell us what's happening.
Oh, yes. Well, this is an individual, a man named Range, who basically had his right to have a firearm denied for over 25 years based upon the fact that he was a felon. Now, being a felon is one of those categories that everybody just seems to accept as an individual who should be automatically disqualified from purchasing and possessing a firearm. And of course, they use, anytime anti-gun advocates use this, they always use it as an inflammatory way. Oh, a felon, a convicted felon, a convicted felon. Well, what a lot of people don't realize is over the last 50 years, we've had an explosion of regulatory crimes and crimes that are nonviolent that have become felonies, both on the state and federal level. And this fellow Range, he found himself in one of those. He was convicted over 25 years ago, basically because he took a plea deal because his wife, of all things, his wife had misfilled out an application form for some sort of state welfare, state food stamp program. And he, in an act of just kind of saying, I want to get it over with.
Yeah, let me pay restitution,
move on. Pled guilty to this, what turned out to be a state felony, and thus it had the effect of disabling him from owning a firearm for the last 25 years. And he finally said, look, I'm not a violent person. I shouldn't be disqualified. And this federal prohibition, as applied to me, should be unconstitutional.
Yeah, so the prohibition we're looking at is under 18 U.S.C. 922 G1, and that says that if you were subject to, convicted of a crime that was subject to imprisonment of more than a year in jail, we generally consider those felonies. Now, they consider this a state misdemeanor, but what the federal government goes on to look at, it's in 18 U.S.C. 921A 20 subsection B. If you have a misdemeanor that's punishable by up to 2 years under state law, they'll consider that a misdemeanor. But if it's more than 2 years, this crime was punishable by up to 5 years, then they'll consider that a felony. So this was a state misdemeanor, federal law. They considered it a felony. And as we can see, not violent.
Right. And I think that that's where this prohibition comes in. Unlike the prohibition that we have discussed previously with regard to people who are 18, 19, 20 years old, they suffered a disability simply because of their status, simply because of who they were. This is based more on conduct where, the state has said, the government has said, look, because you have previously engaged in conduct that we disapprove of, you have now as a consequence lost your rights. But what people have to realize is that with the plethora of state and federal felonies or misdemeanors that carry high sentences like this, each one of these felonies is going to have to be challenged individually to determine whether or not that specific prohibition is one that should be declared unconstitutional.
Yeah, that's a good point. So to bring up the context in which this was challenged, it wasn't like Range got caught with a gun. He wanted to buy a gun, knew he was going to get denied and sued the Attorney General of the United States in order to have, I want to have a right to purchase a gun. And so that's what he was challenging. Now, sued, One, and I think that's an important point because we have kind of two different standards floating out there. The first is as applied challenge, and the second is a facial challenge. The as applied only applies to the individual plaintiff. That's what we have in this case. And then a facial challenge is saying, hey, this entire thing is unconstitutional. This entire statute doesn't matter who you apply it to, it's going to be unconstitutional. Now, we did not get that facial challenge.
Correct, because that would have then, in effect, and one of the dissenters actually pointed this out, a facial challenge would, of course, declare the entire prohibition unconstitutional as applied to everyone. People who are convicted of these bureaucratic felonies or high misdemeanors, include, those folks going all the way up to convicted murderers.
Yeah.
Would be allowed to possess. And, the government basically brought this on themselves because the felon prohibition, whenever it was first contemplated, it just simply should have been acknowledged that it was an overbroad prohibition, that somebody who commits one of these regulatory crimes, a nonviolent crime, otherwise good citizen, should not be lumped into the same category as a mass murderer or an armed robber or a person, a sexual assault or someone like that. There clearly long ago should have been some sort of distinction between a non-violent felon and a very violent felon.
And then I think the last thing that this really illustrates is we had challenges to these non-violent felonies, not that long ago prior to the New York State Rifle and Pistol Association v. Bruin case. The one that comes to mind, I believe, is out of Tennessee. Somebody was convicted of a felony window tint violation. They went through a similar process and the courts upheld that prohibition in that case. But now that we have this new standard, we look at, firearms regulations at the time the Second Amendment was adopted in 1791. Is this something the government regulated at that time? So we start presumptively, all gun laws are unconstitutional. That's where we start. And then the burden shifts over to the government to prove that this is something that they regulated way back in 1791. And I mean, can we imagine someone being deprived of their right to keep and bear arms for filling out a form wrong? No.
Yes, and I think that all the lower courts were just simply waiting. All of the reasonable jurists, all of the jurists who believe in individual rights, who believe that the Second Amendment does protect an individual right, I think all those reasonable jurists in the lower courts, lower federal courts, and state courts as well, were just simply waiting on a case like Bruin to establish a legal standard that they could finally start critically examining these firearms laws instead of just having to pass on their validity because the Supreme Court had not yet articulated a standard. And I think that's obviously that's what the benefit of Bruin is that this is, much like the First Amendment has been litigated for, over a century. The Second Amendment, even though it's been around just as long, has only now come into its own where courts are allowed to not just say, well, the legislature passed it, so it must be a constitutional law.
Yeah. And I think this is, while it is an as applied challenge, I do think that this is a good, taking the temperature on how the New York State Rifle and Pistol Association standards should be applied in, presumably success in the future and other challenges because we're applying that strict standard. So this does have wide-reaching implications, I think. And I mean, this is a huge 107-page opinion. We'll link that in the description below for folks to check out if they're interested. But I think the court does a really good job here.
I think they do a very good job. One thing I think that's important is that this was originally a panel decision that was overturned by the en banc Third Circuit, and they ruled 11-4 that this was a constitutional violation. So that's not even a close case.
No, that is not a close case. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. Check out our friends, Sonoran Desert Institute, Acre Gold, also linked in the description below. And until next time, we're the Armed Attorneys.